A controversial commercial related to the abortion amendment in November's election is allowed to run on TV stations across the state of Florida. A federal judge ruled the state of Florida crossed the line by demanding TV stations stop airing the ad. Rich Donnelly is on your side with a closer look at really some fiery language from a federal judge aimed at the Florida Department of Health. Rich, tell us more.
It's an issue of First Amendment rights related to political speech leading up to the election. The organization Floridians Protecting Freedom created an ad campaign designed to convince people to vote yes on Amendment 4, which would codify abortion in the state constitution. A federal judge says the state went too far by telling local TV stations that they were not allowed to air that ad.
If I did not end my pregnancy, I would lose my baby, I would lose my life.
This is the commercial at the center of a ruling by a federal judge against the state of Florida's Department of Health. The commercial ran on dozens of TV stations across the state of Florida, including First Coast News. Under the current Florida law, abortions can only be performed until the 6th week of pregnancy unless certain factors like pregnancy caused by rape, incest, or the health of the mother are in jeopardy. A cease and desist letter written on Florida Department of Health letterhead was sent to those stations claiming that the commercial is false and dangerous. U.S. District Judge Mark Walker was blunt in his decision to grant a temporary restraining order against the state of Florida's cease and desist order. Part of his ruling read, quote, "To keep it simple for the state of Florida, it's the First Amendment, stupid." End quote. Judge Walker also wrote, "The government cannot excuse its indirect censorship of political speech simply by declaring the disfavored speech is false." Part of a statement by the campaign director for Yes on 4 with regards to the restraining order reads, quote, "This ruling is a powerful reminder that Floridians will not back down in the face of government intimidation." Another one of the criticisms of Amendment 4 is that it would allow minors to have abortions up until the 24th week of pregnancy without letting their parents know. However, that is not true. The amendment text states that the amendment would not change Article 10, Section 22 of the Florida Constitution, which states a parent or guardian must be notified before a minor's pregnancy is terminated. Amendment 4 will need at least 60% of the vote to change the law on abortions in the state of Florida. A preliminary injunction hearing regarding the temporary restraining order has been scheduled for October 29th. Reporting live in Jacksonville, Rich Donnelly, First Coast News, on your side.